Hello and welcome to Legally Speaking with me, Tarun Nangia. Today we take up a very interesting topic on the subject of arbitration. And this is part of a judgment that was delivered by the Chief Justice of India, Justice Dhananjay Yashwant Chandrachud, Justice P.S. Narasimha, and Justice Pardiwala. And the highlight of or the law point of this judgment is that arbitration awards cannot be set aside on a mere possibility of an alternative view on facts or interpretation of the contract. This is a well established principle in arbitration, but even then, time and again, cases come up to the Supreme Court. What is this case? What are the details? This is what our panel will share with you. They will also share with you their opinions on this subject. They all do arbitrations and litigation. Let me welcome my panel today. I have with me Justice Talwant Singh, who joins us. Good to see you, sir, on the show. He is a leading arbitrator. He also appears before the Supreme Court of India. And in his new innings as an advocate at the Supreme Court and as an arbitrator, he's going to be reflecting on this judgment and sharing his opinions with us. Looking forward to your opinions on this today on the show, sir. I have with me Advocate Abhimanyu Bhandari. He takes up arbitrations. He's also, in a sense, an arguing counsel at the Supreme Court of India. Also goes to the Delhi High Court. I have with me Advocate Shashank Garg. He has an arbitration practice. In addition to that, he also is active at the Delhi High Court and the Supreme Court of India. Good to see you, Shashank. I have with me Anirudh Krishan Gandhi, whom we welcome for the first time on Legally Speaking. Anirudh is a partner, litigating partner, what we call the dispute resolution practice at Saraf and Partners. He will bring in his views on this subject. But first come first, let me go to the star of the show today. We have Justice Talwant Singh with us. In about the next 3-4 minutes, if you could reflect on this judgment and make a few comments before we go to the rest of the panel. Over to you, sir.
Okay, thank you, Nangiaji. The main crux of this judgment is the reiteration of the law as it is. I think there is no new interpretation which has been given. This interpretation is already there, but time and again we have seen that the high courts, they try to interpret this law in a way in which it has not been interpreted by the Honorable Supreme Court. I'll give you an example. In a case which was before me when I was in Delhi High Court and I was sitting in division bench, we got a matter under Section 37 of the Arbitration Conciliation Act against a judgment of Section 34 of the same Act, wherein the learned single judge, knowing fully well that there are only two options available before the court, one is to uphold the award as it is or to set it aside. He tinkered with the award. It can't happen. Those days are gone. First thing. Second thing, it is even in the, as far as you see Section 34 and 37, the scope of interfering in the award under Section 34 and in 37 with the judgment passed by the learned single judge is very limited. The Honorable Supreme Court, through this judgment, has only reiterated the general law. Even in normal civil appeal cases, if the trial judge has taken a view on the same facts, and there may be a parallel view, but you can't interfere with the judgment or even of a civil judge on the ground that, look, on the same facts, this could have been the other view. So that is the view of the High Courts and the Honorable Supreme Court throughout, even in civil appellate matters where they have got vast jurisdiction. There the appeal means a retrial. Here the scope is very limited. So naturally the same principle has been applied here. Same set of facts, the same conditions, same terms of the agreement. The arbitrator has given one interpretation which has been upheld by a single judge. So the division bench, in its own wisdom, could not have taken the other view and said that this is the correct view. So you can't correct the view. And moreover, there is a concurrent finding of two stages. Arbitration award itself is sacrosanct, first thing. Second thing, a learned single judge has also given his opinion agreeing with the arbitrator. So the scope for the division bench of Bombay High Court was quite limited, and this is what Honorable Supreme Court has held in this judgment.
Thank you. Thank you for that opening comment. I'll now go across to Advocate Abhimanyu Bhandari. In fact, when I called you to invite you for the show, you were getting ready to appear before an arbitrator in a case. And I said to you how topical that I'm going to invite you on the topic of arbitration. So it is the right mode to start. Your inputs on this issue.
So, Tarun, first, I think that I agree with Honorable Justice Talwant saying that this judgment reiterates and reconfirms the law that High Court should not get into setting aside an arbitral award or tinkering with an arbitral award on unless it is perverse. And if there is no perversity, then High Court should withdraw its hand from interfering into an arbitral award. So a long line of judgment says that, and it's very welcome that this judgment reconfirms that position. It is important that time and again Supreme Court comes down on any interference with an arbitral award where the award is not perverse. Because the minute that is tempered with and that is watered down, the strict criteria that you're not going to interfere with an award, if it is not perverse, it'll open floodgates. Because you don't want a system where, although the law says that if an award is perverse, then only we will interfere, but the definition of perversity is watered down to such an extent that even a mere interpretation of a contract where a plausible view is possible is considered as perversity. Now, this is the problem that we face with. It's very good for the statute book to give this very high threshold. Look, there is no appeal against an arbitral award. It's an application you file to set aside an arbitral award if you feel that it is perverse, it is manifestly arbitrary. So the threshold is very high. Courts again and again have said, the apex court has said that you can't get into the interpretation of the award. But, Tarun, what's the real situation? Let's not kind of just, reiterate the law. Let's ask ourselves, and, we have a panel of lawyers and a retired judge who's been, who've seen a lot of arbitration matters in different capacity. The problem is that after an arbitration is over, and it can take years, although the act says 1 year, we know that it takes years. You get stuck because everybody invariably files a 34 application. And the 34 application goes on and on and on. Although the act says it should be completed in 1 year, but it's not possible because we don't have the judicial infrastructure to deal with tsunami of arbitration awards coming in and clogging the system. Then there is a 37 appeal position. So really, we need to now control ourselves to an extent that we don't allow any court to interfere with an arbitral award unless it's actually perverse. And it's not, if someone feels it's not fair. I actually feel, the damages should have been less than what has been awarded. That you may feel that way. But unless you feel it's so unconscionable and perverse that no judge could have passed an order like that, or there's something really unconscionable about it, then only do it. For example, Tarun, in the UK, they go very strict and they say that there has to be a serious irregularity. The word they use there is, there has to be a serious irregularity. And rather they compare it to a situation where probably an award has been procured by fraud or corruption or by some other underhand means. I think we need to now, what's happened is the situation is that we have these large number of awards where a lot of judges, and justifiably, Tarun, a lot of high court judges would probably feel that I think here the arbitral tribunal has gone a bit too beyond or a bit too generous in favor of granting damages. Also understand the large damage awards are really against the government or an entity of the government, whether it's a road constructing company like NHAI or it's a big PSU. And then, a judge probably feels that is this fair on the state to give, to have loss of profits runs into thousands of crores or multiple of hundreds of crores, and then notice is issued on that 34 and keep spending. Now, there are both sides of the coin. One side which says, look, you got to dismiss it on day one. You got not to interfere unless perverse. But also look at it from the other side, where a judge is sitting there and he's feeling that the state has to part away with a huge sum of money, and he feels that the arbitral tribunal may have gone a bit beyond in generous in giving what the award is. So now the question arises, What do we do with these two competing interests? What's the solution? I think the solution is that every time a high court feels that the arbitral tribunal has gone a bit too beyond in granting a measure of damages or in giving an award or probably not giving an award, rather than trying to tinker with that award or set aside that award, it should send the matter back to the arbitral tribunal to give its opinion on the point which prima facie is hurting the conscience of the judge and address that point within a given time period before going ahead and trying to interfere or setting aside the award. If this course is followed, then a large number of cases will finish very quickly. Now, the Act has a provision under Section 34(4).
Yeah.
The problem with 34(4), Tarun, is that it asks that one of the parties should recommend to the honorable judge or to the court hearing the matter. That's, I think, a problem. It should be suo motu. If the court prima facie feels that there are grounds which probably could be addressed by the arbitral tribunal, which would eliminate setting aside of the award, then it could always refer the matter back to the tribunal and set out that, look, these are the 3 objections I have. What do you have to say about it? The arbitral tribunal, within a time period, can then come back and give its view. Look, maybe that view satisfies the conscience of the judge that, no, the arbitral tribunal actually thought about it. So if they are giving 300 crores as damages, they had some logic behind it. The court might feel, no, sorry, actually there was no logic. It's completely perverse. And then they can set it aside. But I think that would solve a lot of the problem. One. Second, after the 34 proceedings are over, so we've now completed a huge amount of time arbitrating. Then we go to a 34 court, which takes its own time. I think 37 notice should be only issued in really exceptional cases. And I think an amendment should be brought in to make the scope far more narrower at the 37 stage than what it is at the 34 stage. Because really, this is like a second appeal. And unless it's an exceptional case where, someone is not even, which patently, which on the face of it is perverse. I'm forgetting, but a very interesting phrase was used by Justice Nariman in Deep Blue Sea. I think that was a case where he said that a writ court should not interfere with an arbitral order unless it's patently on the face of it so perverse. So I think those are the words we should borrow, and we should kind of give a guideline that at the 31 stage, you need to be absolutely strict in ensuring that none of these matters you even issue notice. Because if notice is issued at the 31 stage, you spend another 2-3 years in a turmoil, even after you won the arbitration and after you won the 34. Now, Tarun, in your shows, you've been talking about that India needs to be a 5 trillion economy and what we need to do about it. And one of the features which was brought in was the IBC, which completely reformed the way business does. Now, look at the problem. In IBC, an operational creditor can go against a company and ask for a resolution professional to be appointed, or a financial creditor can go and immediately ask for a resolution professional to be appointed over the company and take over the company and the management of the company. What if this company has a huge amount pending in an arbitral dispute? And that arbitral dispute, he's won the arbitration award and it's pending in a court of law. So it can really create a mismatch where funds are not coming from the arbitration, which he has won. And in the meantime, an RP is appointed because he's unable to pay his debtors because there are no funds coming from a litigation which he has won. So while we have really strengthened our IBC mechanism, which is being used as a recovery tool, although we say IBC is not a recovery mechanism, but yes, in practice, it is one. We need to do the same thing with the arbitration to ensure that corporates in reality can actually get their money within a time-bound period. Getting your arbitral award after 10 years or 15 years is too late. By that time, the RP has been appointed. There will be a resolution plan. Someone else will come in. And the poor promoter who built his company goes out. Someone else comes in, buys it for a song, and then enjoys the arbitral proceeds. So according to me, this is a complete mismatch. So therefore, I think urgent reforms need to be brought in the Arbitration Act.
Thanks for sharing those views. Frank, as usual, you are on the topic. I'll go to another person who's known to speak his mind, whether on time, cost, and delay in arbitration some time back. Shashank Garg, who's active in the field of arbitration also. Shashank, your views on this judgment and the message given by the three top judges of the Supreme Court of India.
See, Tarun, as stated by speakers before me, there are some key takeaways of this judgment. While it certainly reiterates the law already settled by the Supreme Court, but those key takeaways, we need to remind ourselves again and again. First, let us understand what is the scheme of the Act. The scheme of the Act provides two windows, first in a Section 34 and then in a Section 37 for anybody to go for setting aside of an arbitral award. Now, as already discussed, the window in 34 itself is very, very narrow. The parameters are very, very strict. The two main grounds for setting aside of an award is if it is patently illegal or if it is against the fundamental policy of India. And patent illegality is only available if it is a domestic award. Now, with these two very narrow parameters, when we go to 37, which is the second stage, the window becomes even more narrower. But the question is that if 34 itself is so narrow, why should we have a 37 at all? So the 37 court, in my opinion, is to only see any manifest error done by the single judge in application of these fundamental, principles enshrined in Section 34. The 37 court should not enlarge the scope of 34 itself. It is only there to see if the 34 judge, the single judge, was able to appreciate the award in the fine contours that are given in the Section 34. And that is why, as rightly stated by Justice Talwant Singh and Abhimanyu, that the court in 37 is not sitting as a court of second appeal. So it is even more finer and reduced scope. Now, what we are seeing practically is everybody mechanically challenges an award up till the Supreme Court. And most of them are public sector undertakings. Even otherwise, private parties also take their chances up to the Supreme Court. But after the amendments were brought in, and at the stage of 34, everybody is now being asked to, make a 100% deposit in almost all cases. Life is becoming slightly difficult for parties who actually do not have a good case in 34. The change that can be brought about is that when there is a mechanical challenge to 37, the 37 court should not stay the award. That means that at least if somebody is successful before the tribunal and has also succeeded before the 34 court, he should get his money out. What we are seeing, and Delhi is a good example. We are a very, very proficient commercial court. But if you look at the country as a whole, the backlog of 37s across the country, once the notice is issued and the stay continues, the successful party who was succeeded before the tribunal and who was succeeded in the 34 will have to wait easily for a few years before it can see the color of money. And then, the losing side may take their chances in the Supreme Court. So there was one very interesting thought that was discussed by Justice Nariman once in a conference and then repeated quite a few times, was that we should completely do away with 37. After 34, there should be SLP. There is no need for a second tier window at all. I don't know if the legislature has taken it seriously. I don't know if it is, in the zone of consideration with the current committee or not. But I think that could be a very, very welcome step, because we are seeing how Section 37 is being used and abused by erring parties.
Point very well taken on Section 37. That could be a topic in itself. I will request Anirudh, Gandhi, partners, Saraf and partners to reflect on the judgment, the message sent via this judgment, and also his comments on the issue of arbitration at large.
Yes. So I'm thankful to you for the invite. What I think this judgment reiterates is the law which was already there. The law being that the appreciation of evidence or the erroneous application of the law cannot be looked into at the stage of 34 and 37. The jurisdiction at the stage of 34 is akin to jurisdiction at stage of 37. The grounds are very limited. The legislature, in fact, notes that erroneous application of law and reappreciation of evidence is not a ground to set aside the award. Notwithstanding so, the courts sometimes look into this. The reason I feel is because it is difficult to sometimes distinguish between what amounts to rewriting of the contract and what amounts to a plausible interpretation of the contract. The case at hand falls in this category. The division bench interprets something as a rewriting of the contract, which single judge and the Supreme Court feels is a plausible interpretation of contract. So that is the major problem which has been faced here. The division bench, while rejecting the view taken by single judge, notes that if there are two constructions which are possible, the interference which gives effect to all clauses should be preferred. Unless that is done, the award would be perverse. Now, it is important to understand what in reality amounts to perverse, though it has time and again been reflected by the Supreme Court. The perversity for the purposes of Section 34 is a different perversity in comparison to an appeal, which is concerned in a civil jurisprudence. The perversity is where irrelevant facts are taken into consideration for making a decision, or where the relevant facts are not taken into consideration for making a decision. Therefore, if an award is based on little evidence or an evidence which does not measure up in quality to a trained legal mind, that would not amount to a perverse award. That award would stand the test under Section 34. So it is very important for the courts to defer to the view taken by the arbitral tribunal, unless that view is impossible, or it is something which is based on irrelevant fact and outcome results in an unjust enrichment of one of the parties, in which case it will go against the public policy. Now, I heard the panelists before me, and I was very much intrigued by the views expressed by Mr. Garg. I also think that there should be a possibility to waive not only 37, but also 34. While the mandate under the Arbitration Act is to respect the finality of the award and the party autonomy. The party autonomy, I feel, should be extended by giving parties an option, express option under Section 34 and 37, that waiver, if they want, under the contract, they can waive their right to set aside the award and to appeal against such an award under 37. Both sort of waivers should be allowed. If parties want, they can have just the waiver under 37, or they can have both also. That is a practice which is followed in some of the foreign jurisdictions, and I think it's time that should be allowed here also. Though I understand there may be problems, and some grounds may be non-waivable, like public policy, but in a very restrictive way. Some grounds can be retained, but other grounds parties should be allowed to waive. That would help the award to attain finality at an earlier stage, and that would also respect the commercial wisdom on account of which the parties have entered into arbitration agreement.
Now I'm going to take this issue to Justice Talwant Singh. Sir, if an arbitral award is being reviewed by a judge and he feels that I should do justice, is that a problem, that if you want to do justice, then on commercial issues, two views are always possible? So when judges veer on this fact that, no, I have this, now I will now do justice, let's see what the tribunal has done. What will this lead to?
Yeah, Tarun, the Arbitration Act is to be read as a whole. If you read the entire Arbitration Act, the spirit of the Arbitration Act is that court should keep its hands away. It's not as some dispute which has arisen under the Commercial Courts Act or maybe under CPC. Okay, so that I think we have to keep in. The problem is even in Delhi High Court and other high courts, same judges are hearing the commercial disputes on the appellate side. Same judges are hearing the civil disputes on the appellate side, or maybe on the original side also, like in Delhi High Court and Bombay High Court. And same judges are hearing the arbitration, Section 34 and 37. So we have to wear different hats, which sometimes we forgot as judges. So the grounds on which you can set aside a civil judgment in a civil case, or maybe a judgment rendered by a commercial court, those grounds are not available. We have to keep this in mind. And I agree with the other panelists regarding the scope of Section 37. And why shouldn't a person who is in whose favor the arbitration award is there and who has won the first round in the court in Section 34, why he should not enjoy the fruits of the arbitration award? So one thought which came to my mind when I was hearing these these arguments is that I think some provision can be made, and it is though no, because once we talk about amending the act, it's a long procedure. The legislature has to take a call. So even you must have seen in many cases, the Honorable Supreme Court and the High Courts, they have time and again, pointed out lacunas in certain laws, and they expected the legislature to take a call, but it takes time. It is not done in a day. It is not done in even months or years. So what can be done is that I think it is again the judicial conscience of the judges sitting and hearing Section 37 matters is that if a person has won first two rounds, that is arbitration award in his favor, and then in Section 34 also the learned single judge has agreed with the same party, the other party must have challenged in Section 34, then that person may be allowed to enjoy the fruits of the arbitration award, subject to furnishing of some bank guarantee or something to satisfy the court that if tomorrow the award goes other side or the court is not agreeing with him in Section 37, then there is some security for the other side. This is what we were doing when I was sitting in division bench with the other senior judges, and we were following this practice. At least because the date the dispute arose, the arbitrator appointed, arbitration award came, Section 34 filed, decided. It may be minimum gap may be 5 years, and the maximum may be 1 decade or 2 decades in some cases. This is what we have seen. Yeah, I'm sure about that. So this, and the money loses its value. The money of 1 crore or 10 crore, which was there in 2001, it is not the same value in 2023. Yeah, even if you upheld the award after 10 years, the person is already a loser. He may have some bank loan to pay. He may be declared an NPA. Or maybe IBC proceedings might have been started against him. So we have to keep that in view. You can't run a business where the award in your favor and you are unable to reap the benefit of that. I think my co-panelist has raised a very valid question that in IBC, suppose a company, an RP has been appointed, and what he inherited, what he got is number of appeals pending or number of appeals or Section 30 or 37 pending. What he will do with that? Even if an RP is appointed, so naturally there is no shortcut way under which he'll get Section 34 or 37 expedited. That is again a problem, whether the company is to be rehabilitated or it is to be wound up. These proceedings will come in way. Once we have taken such a welcome step of coming up with the IBC code, I think some changes are required on the arbitration side also. This is my take on this.
Thank you so much for sharing that input. I'll go across to Abhimanyu Bhandari. I have a 3-tier question for you. Tier 1 is the view of the investors sitting in New York and UK, who are large investors in India. Investments also coming from Australia, Japan. They look at dispute resolution mechanism in India. For infrastructure companies, arbitration is the major route. But if courts get into the habit of getting justice, of course, there will be judgments like these where the 3 top judges of the Supreme Court have sent a strong message. What needs to be corrected in our arbitration system? This habit of doing justice by the courts, will it land us into a situation where there would be no end to a dispute in 5 or 7 years, resulting in what Justice Talwant Singh rightfully said, that money loses its value. If your interest cost is more than the money that you have to receive, then money has lost its value. On a 100 crore compensation, if there is 100 crore interest that you have to receive, the government is never going to part away with that kind of money easily. Your input on that. And of course, when you're talking of infrastructure, $150 billion are spending in India over the next 10 years. There are going to be so many disputes. Is our system, arbitration and the courts capable to handle that? You're not audible.
So, Tarun, it's a very important question you've raised, is that the money loses its value. You see, getting a decree and then actually getting the decree executed and getting the money in your pocket can take years and years. Justice Talwant Singh says 5 years, and it could go up to 2 decades. That is absolutely horrifying, because in the meantime, that company may have operational creditors to pay, financial creditors to pay, and that company may go out of the hands of the promoters within a jiffy, because our IBC system is so strong. So we made an IBC system which is very strong, but we haven't had the corresponding changes in adjudicatory processes where people want to get their decrees enforced or get a decree after adjudication. So we need to address that situation with a lot of thought and urgently, to create the right balance. Now, you ask me, what would that investor sitting in America, New York, a big fund investor who's invested money in India would do? Well, we should not forget, I think the judgment of white industries still haunts us. We should not forget that in investment treaty arbitration, courts have held, ICSID has held, and also international tribunals have held, that if an investor has invested money in your country and you're bound by an investment treaty provision, and his decree is not getting executed, or it's taking a lot of time for him to recover his money after having a legitimate decree in his favor, then that could tantamount to expropriation by a sovereign state, because the sovereign state is not providing the necessary judicial infrastructure for that investor to realize his amount even after getting a decree in his hand. And therefore, the state will be liable. There is the judgment of white industries. So, as you know, Tarun, India is a signatory to many investment treaty arbitration and will be in the future if it wants to create this $5 trillion economy. We are it's a very proud moment for our country, where we are hosting the G20, and we are taken as a serious partner in the world economy today. And therefore, it is going to be increasingly demanded by other countries that we sign investment treaty arbitration agreements, just like UK has signed with various countries, and just like EU has signed with various countries. But the minute we sign that, because some of them have expired, but when before we had signed those agreements, the problem was that if a foreign investor was not getting his money after getting an arbitral award in his favor, and it was in a turmoil because it was stuck in the court process, they could sue the country, and the country would have to pay. So in the international tribunal or in the ICSID, wherever the investment treaty arbitral tribunal's jurisdiction is. So that's another very scary situation that we can find ourselves in. Therefore, Tarun, it is very important that we actually try and do something and amend our Section 37. Now, there is the Honorable Justice, the judge said, that in 37, we will ask the other party to give security and bank guarantee. I'm sorry, while I would love to agree with him, I think that's a bit too little, too late. What will I do with a bank guarantee? I need monies to pay my employees. I need monies in my bank account to pay, and I don't have the bank guarantee to give you. If I have 1,000 crore decree from a big power company owned by the state who's not paid my power bills, and I've generated the power, how do I pay everybody else? What will I do with the security that you give the 37 court? I'm sorry.
1 minute. Mr. Bhandari, I said the other way around. You get the money, the winner will get the money, he will give a security to the other side.
Very well. Very well. No, I'm not. I agree with you. I think that's a step ahead to do something. But I'm saying that's also too little, because giving that security in itself is a punishment. I have won my arbitral award. I have won my 34. At 37, you're asking me give security. Where do I get this security from? My entire revenue is from a PSU. Let's say, sir, I put all my money to build a road for NHAI. And if NHAI doesn't pay me in time, and I'm stuck with the 37 court. So according to me, the root of the problem is that the 37 court, and I think this judgment is a judgment which talks about the 37 process more than the 34, because here was a case where the 37 court set aside the single judge order and tinkered with the arbitral award. So as far as 37 is concerned, we need to now ensure that we have necessary apex court against reconfirms and states that the 37 court can only interfere if a single judge's order is so patently, manifestly arbitrary that no single judge could have passed that order. So I think 37, because what I see from practice, and I may be wrong, other panelists might have a view. I feel that after the 34 is over, many times notice in 37 is issued because the division bench also has to write an order. Sir has sat in the division bench for many months. Division bench can't simply say, we agree with the single judge, dismiss. They have to also themselves apply their mind and write a detailed order. So according to me, we should have necessary amendments in the act which says that 37 court will only issue notice after the single judge and record that what is so perverse and manifestly arbitrary that it is forcing them to record to issue notice in a matter like that. That kind of threshold has to be built in the 37, or this is going to be a long process. 34 has to complete in 1 year, and we need to have more. The larger issue is we need to have more commercial judges on the commercial side, so that arbitral awards which are more than in 1 year the 34 process completes. Yes, the courts have gone hammer and tong to ensure that tribunals now complete the process within a year. And we've seen some very good judgments on that. But according to me, we need more commercial judges to ensure that. Or we are going to have a complete mismatch where a lot of good companies which are owed money will go into bankruptcy. And you're right, Tarun, please tell me, if for 10 years an arbitral award is sitting judicial scrutiny and the interest is going on, do you think the state is ever going to pay that? It's going to go up. And why should it? Also, we need to also have process where people who are appealing and giving instructions to appeal these awards should really think the long-term ramifications on the economy by appealing such awards. And while we have a lot of scrutiny on people, why they don't sign the file for an appeal, we should have the same scrutiny when someone, is firing the gun and making a note that let's appeal. So these are changes that need to be brought in.
Point very well taken. Thank you, everyone, for those views. I'll go to Shashank. Shashank, India has a unique position. In India, a lot of retired judges have become eminent arbitrators. So they have had a distinguished career as a judge. When other judges tend to sit in judgment over their arbitral awards, I find it a bit funny, because it is one thing that you may disagree with the arbitration bar, which consists mainly of lawyers. But India has a unique position. I reiterate that so many eminent judges go on to become arbitrators. How would you reflect on this dilemma? And the dilemma of a judge whose arbitral award is being reviewed?
Tarun, it's a very pertinent question. Now, I must tell you something I was pondering upon when everybody else was speaking. The Arbitration Conciliation Act, Section 28(2) expressly says that the arbitrator is not entitled to decide cases on basis of justice, equity, good conscience, unless expressly authorized to do so. I do not know any case that I have dealt where parties have said, please, Mr. Arbitrator, decide our case on the basis of equity, justice, and good conscience. Everybody wants commercial justice because these are commercial disputes. When that is the parameter under which the arbitrator is to act, how can the court have a wider parameter than that? How can the court then apply justice, equity, and good conscience into looking in an arbitral award? So that is the point I think the courts must reflect upon. And Supreme Court, through these landmark judgments, including the Konkan Railway judgment, is reiterating the same position. I think it is as simple as that.
Okay, point well taken. One quick follow-up question, Shashank, before I go to Anirudh. You are looking at the arbitration landscape in India on a day-to-day basis. India suddenly is seeing a lot of money coming into India. Big highways are being built, mega projects like station redevelopment, airports, and with vendors, disputes are a commonplace. There are ongoing disputes in construction contracts. Are we ready to handle this deluge of disputes that are going to come to India in the next 3-4 years? Are we ready? As the arbitration bar ready? Are the courts ready? Because if this doesn't happen, then investment will grow to a creaking halt.
If you want an honest answer, I think we are absolutely ready in terms of infrastructure, in terms of legal skill, in terms of quality of arbitrators, in terms of robust judiciary, in terms of what we have as a legislature. Now, the only problem is that all of these limbs have to work together in harmony. That is where the main problem is arising. If all of these limbs, which are otherwise capable to handle the onset of arbitration, the surge in disputes that we are seeing right now, and it is only going to increase manifold, given the India is looking to become the third largest infrastructure economy of the world. I think we are fully equipped. It only requires discussions like these, judgments like these, and a good mindset of all the stakeholders to come together and support the arbitration ecosystem. I don't think we require a lot of effort. If everybody is ready to do their job, we are absolutely ready.
Point very well taken. Anirudh, in my interactions with infrastructure company, general counsels, senior management, promoters, they say a lot is dependent on this arbitral award, a lot is dependent on that arbitral award. And I asked them, does it matter to you so much? So they then explained me the working capital cycle. They say if this much of money is taken out, the whole cycle collapses and the whole project goes into disrepair. So you are seeing only X amount of money. You're not seeing the rotation of money in the ecosystem. Do you think we are being unfair to our infrastructure companies? Because I'm singling out infrastructure only for a reason that they are the most cost intensive. They rely heavily on bank money. So when there is judicial delay, the banks get affected. The company, of course, gets affected, but the banks go into crisis. Can you reflect on that?
Surely. I think that's an interesting perspective to look at the things. While deciding a matter under Section 34 or be that matter under Section 37, there are competing interests involved. One is the interest of the award holder. Then there is an interest of the person against whom there is an award. So both the interests have to be balanced by the court strictly under the parameters of Section 34. While it may seem it is unfair that an award, the award holder is allowed to reap the benefits of the award, what needs to be understood is that there are ways in which those unfairness or the other issues could be tackled by way of awarding a future interest on the awarded amount, or by ensuring that if an award is stayed, then a bank guarantee is being deposited in the court. Earlier in the panel, Justice Talwant Singh reflected that if in appeal, one of the parties is allowed to enforce their award, they should be depositing, a suggestion came that they should be depositing a bank guarantee. While it may seem a little too much from my practicing angle, the award holder, instead of giving a bank guarantee and award, a person who is challenging the award should be giving this sort of a bank guarantee when an award is challenged under 34, because the issue is moment the 34, 37 SLPs are disposed of, there is a huge problem of enforcing the award. While technically under Section 36 and 34, the enforcement and setting aside can go in tandem. As Mr. Garg reflected in earlier, that apart from Delhi or Bombay and maybe Calcutta also, which are more commercially savvy, there are courts in which the stay is a norm still, and it is very hard to enforce the award once 34, 37 SLPs are decided. So it remains a mere paper award. And once such, like if we see really 34, 37s and SLPs pending for huge years, like I am witnessing a case where it's a construction contract of 2003, and it took 6, 7, 8 years for the award to come, then 4, 5, 6 years for the 34 to be decided, and a couple of years for 37, and now the SLP is pending. Till now, the award has not been enforced, and that's why there is a problem that foreign investors are shying from choosing India as a seat. That's the biggest problem. If India is not the seat, then the Indian outlook is not clearly appearing as an arbitration-friendly outlook, and we are losing on a lot of opportunities which can be there, which are going to Singapore or other jurisdictions. If we see the Arbitration Act in Switzerland or in Singapore, we'll see the practice is not just in the letter; it's in spirit also. Here, there is an act which is put in place, but all the things are not working in tandem and harmony. So it's a matter of that all the things are put in harmony. And I think it's an opportune time that we're discussing that the expert committee is reflecting on the changes, and maybe if they could reflect on waiver or the bank guarantee provision or other things, it could help in making India a bit more arbitration friendly, and to at least have the seats of arbitration in India for some other matters also.
Thanks, Anirudh. With this, we bring to a close our two-part series on the issue of arbitration and the judgment, where a strong message was sent by Justice Dhananjay Chandrachud, Justice Narasimha, and Justice Pardiwala. I have got ideas for the October edition of our show on arbitration from the views that panelists echoed today on the show. You will find these topics in the coming few weeks. But I would like to thank Justice Talwant Singh, to see him in his new avatar this time as an arbitrator. Looking forward to have you on many more shows, sir. Advocate Abhimanyu Bhandari, who also echoed his views frankly. Shashank Garg, always candid with his views on the issue of arbitration, which is also close to his heart in a sense, this issue. Anirudh Gandhi joined us for the first time, a partner from Saraf and Partners in the dispute resolution practice. Good to have you, Anirudh. Thank you, viewers, and thank you so much, my panel, for joining me. Thank you so much.
Thank you.
Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.